morning. Please be seated. We're here on file number 2025-0290, State of North Dakota. Oops, I have the wrong file. Versus Defendant Pope. Sitting today, sorry. Would you please identify yourselves for the court?
Ethan Langang.
Mr. Langang and
Sean Peterson.
Sean Peterson, excuse me. I've managed to draw the wrong file from my desk, but I do have it electronically, so we'll be all right. So sitting this morning is our justices Jared Tufte, John Jensen, Douglas Barr, Mark Fries, and I am Lisa Fair McEvers. So Mr. Langang, you can proceed as you're ready. It's all right. I've got it.
Madam Chief Justice, Justices of the Court, opposing counsel, may it please the Court, I'm Ethan Langang, and I represent the defendant and appellant in this matter, John Bruce Pope. This appeal arises from the lower court's revocation of Mr. Pope's probation and imposition of a 20-year sentence in its amended judgment entered on October 29th, 2025. Before this court is a narrow issue, that being whether the lower court substantially relied on impermissible sentencing factors when it resentenced Pope following his probation revocation. Specifically, whether the lower court substantially relied on allegations relating to the dismissed charges in the present case and those dismissed in Burleigh County Case 08-2025 CR 01492, which for our purposes today I'll refer to as the child abuse case. This issue can be broken down into, I believe, three fundamental questions. One, did the lower court rely on allegations relating to dismissed charges when it resentenced Pope at revocation? Two, did the lower court, in doing so, rely on an impermissible sentencing factor? And three, was such reliance indeed substantial? I plan to show today that the answer to all three of these questions is yes. Turning to the first question, the lower court relied...
If I can interrupt you, half your appeal we should get rid of right away, right? I mean, the court has existing case law that says denial of a Rule 35B motion is not an appealable issue, and your notice of appeal and your briefing appeals the objection to the revocation and the motion for the Rule 35 reduction of sentence. You agree that that is not an appealable issue?
I agree that generally, Mr. Justice, that Rule 35 motion for leniency would not be an appealable order. However, I would argue that the judge's order in that case related to both the objection that was filed in addition to the Rule 35 motion. So I would say, to the extent that we're arguing leniency, sure, the court shouldn't reconsider the lower court's denial on the Rule 35 motion.
And you also timely appealed from the criminal judgment itself, did you not?
That's correct. All right, so turning again to that first question, the lower court relied on allegations contained in that affidavit of probable cause, which were unproven, unadmitted, unadjudicated, and related solely to dismissed charges.
Is the error there an evidentiary error? Because Rule 1101 says rules of evidence don't apply. So what's the error to rely on such things in sentencing?
So the error here, or the abuse of discretion rather, would be, these charges were dismissed.
As part of an agreement.
That's correct.
Is there a difference between dismissing because there isn't adequate evidence, or dismissing for some other reason than when it's part of a plea deal?
Well, Madam Chief Justice, I would argue the effect is the same either way. The charges are dismissed. The defendant is no longer on the hook, so to speak, for those allegations, for those charges.
Is it your position that had the state brought in evidence and presented it at the sentencing hearing, the court could have considered it? It just cannot based upon the affidavit?
Are you referring to the original, where the court accepted the plea agreement, or the revocation?
Either time.
Okay.
If some facts were presented rather than just an affidavit where the matter had been dismissed, could the court have considered those facts in determining sentencing?
I would agree that the court could consider that at that point, but this is unlike that. There was no evidence really presented aside from the affidavit, which the court, for all intents and purposes, seemed to almost blindly rely on, despite assertion from then counsel for the defendant. And I would note my representation of Mr. Pope began with the revocation matter. Another attorney, partner at my firm, Garrett Ludwig, had represented Mr. Pope from the initial case up until when Mr. Pope changed his plea and the lower court ultimately accepted the plea agreement.
So and sorry, we're stepping all over your outline, and you're probably not going to get back to it, but
okay.
If reliance on that affidavit that was the basis for the charges that were later dismissed, if that's the error, explain to me how this would work if he was never charged at all on that other conduct. You had the same affidavit from the same alleged victim providing information to the court about the bad character and the propensity for violence and other things about this defendant. If he was never charged at all, couldn't the court use that affidavit?
Are you meaning if he was never charged, like the child abuse case was never
Right.
charged? Okay. Well, if he was never charged in that case, that affidavit wouldn't exist, would be.
But you're fighting the hypothetical. Suppose you have
Right.
an outside witness, a witness who's not in front of the court, but who's willing to swear an affidavit saying he abused these children in such and such a ways on such and such a dates, and that shows his character, his tendency, or his ability to be rehabilitated, other things relevant to sentencing. And that's given to the court by the prosecutor. Can the court rely on that?
Absent testimony supporting that, I would argue no.
Despite the fact that the rules of evidence don't apply at sentencing? What's the basis? Is it due process, something else?
I would argue, yes, it is a due process issue. In addition, this court has said repeatedly that sentencing courts have broad discretion in issuing their sentence. That includes matters such as whether a sentence is concurrent or consecutive, and so long as the sentence is within that statutory limit, this court is constrained in its review to whether the court relied substantially on an impermissible sentencing factor. And that's really the crux of our argument here today, is that with the court relying on that affidavit and the child abuse charges, despite them being dismissed, despite there being no adjudication of those issues, that in doing so, the court was relying on an impermissible sentencing factor.
Are you suggesting, when you indicate that there's a due process concern, are you suggesting that your client's right of cross-examination or the confrontation clause was somehow violated by the court, or what, just the broad umbrella of due process? Help me understand what your argument is.
Sure. I would argue that, yes, his right to cross-examine witnesses has been impeded. That officer is never subject to cross. His right to a trial by jury is also, at that point, gone. So that lower court is saying, we're gonna consider these allegations without giving you, Mr. Pope, the opportunity to contest them. We're just gonna accept what the affidavit says is true, despite the fact that we have defense counsel in the original sentencing hearing arguing that the CDC interviews, which the court made clear it had large issues with, wanted to see the state filing hearsay exemption requests. Then defense counsel indicated that each of those interviews showed that the kids actually denied that their father, Mr. Pope, had abused them. The state attorney at that time, which is not Mr. Peterson either, also indicated similar concerns with respect to the victim's credibility. Do you have a question?
I do, but you can finish your thought if you
Okay.
need.
I'm ready.
I mean, you
Go
just
ahead.
have a hot bench today, so that
okay.
makes it more fun. You responded to Justice McEver's questions about whether the fact that there was a plea agreement makes a difference, and you said no. Does your client get the benefit of the plea agreement of dismissing those charges if they are considered in sentencing?
I would argue no, he doesn't.
So is there a distinction whether there's a plea agreement to dismiss them or whether they were never brought?
I suppose in that case, yes, there would be. To your point, if the initial benefit of that plea agreement is the child abuse case, those 5 charges are dismissed. For the court to then, on revocation, essentially for our intents and purposes, reopen and reconsider those facts, that benefit is lost.
But that completely discounts what the district court said to your client at sentencing. If you come back, you're likely going to get the max, and it was 5 days until he violated that order. The court said what it was going to do, and it did it. How can you ever get past the reliance on the impermissible factor, even if it's impermissible? even if the court relied on it, how can you get past what the court told your client she was going to do, and then she did it?
Well, Chief Justice, I would argue that the court in issuing that warning was already relying on impermissible sentencing factors. This court has made clear that relying on a pending charge is impermissible. And that's what the court was doing there.
The charge isn't pending. Oh, you're saying that it was pending at the time it
At
considered.
the time of the warning, yes.
I see what you're saying.
Yeah, so at that point, it was already relying on that. And as soon as those charges were dismissed, at that point, we're arguing that there's no longer any basis for the court to
So
consider.
what was the level, the cases that were dismissed, and there were a number of charges, were they misdemeanors and so that they were dismissed and then your client pled to the felony terrorizing? And the other cases that were felonies?
So the child abuse case were 5 felonies, 2 B
They
felonies.
were all felonies, okay.
Yep, 2 B felonies, 3 C felonies. In this case, it was originally 6 C felonies and 2 B misdemeanors in this case. And he pled guilty in this present case to the simple assault, C felony, preventing arrest, C felony, disorderly conduct, B misdemeanor, and then 2 terrorizing adult victim domestic violence.
And I thought one of the terrorizing included the children, did it not, that he pled guilty to?
No, Your Honor, it did not.
Okay, only the domestic violence? Terrorizing domestic violence?
The threats to the spouse or
Threats.
the lady.
Right,
They're
yeah,
married.
Okay.
it was only relating to the wife, nothing with respect to the victim, or I'm sorry, the children in this case. So,
Counsel, would you agree that it's fairly common for there to be letters submitted during sentencing, both in support of a lenient sentence as well as letters in support of a more punitive sentence?
absolutely.
Okay, so here's my question. Why are those letters not a problem, but Justice Tufte's suggestion of an affidavit is a problem?
So, with respect to the victim, or, you know, and in most cases it is a victim impact statement, you really,
Not all of them.
I'll agree with
Some of them are
you,
just people
sure.
writing in because they have an interest in the case.
Right, so to the extent that someone is a third party, whether it's the victim or someone else, is making a recommendation or asking the court to do something, I'm sure the court can look at it, but for the court to accept that as true, for instance, if a crime were alleged in an additional crime were alleged in one of those victim impact statements or something else, I would argue
Ever
that.
held that?
I'm sorry?
Have we ever rejected a letter, either for leniency or for a further punitive sentence? Do we have a case that says you can't consider this particular letter?
In my preparation and research for this matter, I did not find any cases that held that.
So why is it that if it's an affidavit, it's a problem, but if it's an unsworn declaration, just a letter, there's no problem with it?
I would argue there's a distinction between the two. The affidavit is going to be prepared by law enforcement who's tasked with enforcing our laws, who's
We
tasked.
should just tell the law enforcement to write a letter.
No, Mr. Justice, that's not what I'm
But
arguing.
that's, I'm struggling with, where do you draw that distinction? And again, it's the follow-up on Justice Tufte's question.
I would draw the distinction at when there's letters either in support or against, let's say, a lighter sentence. Those are going to be folks weighing in on what they think it should be. It's typically not the case where we have new crimes being alleged, different behaviors being alleged, where the affidavits of probable cause are directly related to this is established for the purpose of finding probable cause with respect to the charges that are alleged, either within that affidavit or in a criminal information filing.
Right. I guess fairly recently, maybe not recently, but fairly common now in media are reports of sexual assaults, prosecutions for sexual assaults. There's a lot of Me Too letters that are submitted. Those are assertions of additional crimes. Those are assertions that this defendant did a similar act on me. Those aren't rejected, right?
I guess in my preparation for this case, that was not an area of focus, so I
Okay.
don't have argument prepared for that exact question. Another point I want to get to here, with respect to the plea agreement, I want to read the specific conduct that Pope admitted to in that plea agreement. Specifically as to count 1, John Bruce Pope recklessly kneed Deputy Thomas Parisian in the groin while preventing arrest. Count 2, John Bruce Pope physically resisted deputies' efforts to arrest him, which caused law enforcement to use substantial force to effectuate his arrest. Count 4, defendant spit on his wife. Count 5, I'm going to show you who Mr. Pope is. This is my final warning. And count 8, threatened that I'm not afraid to die. You think I'm effing playing? I'm not. And what I said 2 years ago still stands today. Some cops come here and I'm here with you. What I've just read is the lower court's entire factual basis for the sentence and accepting the plea agreement. Mr. Pope did not agree or endorse any of the other allegations either in this affidavit or in the affidavit pertaining to the child abuse case. Despite that, during the revocation hearing, the lower court made numerous unfounded conclusions that Pope was a narcissist, abused his children, both physically and mentally, and prevented them from going to school to hide that abuse. Some of the very allegations we saw in the child abuse case. Some of the couple quotes I want to read from the revocation hearing.
Mr. Langen, if I could stop you there, and that's what's really bothering me, is how do we know that the judge relied so much on this uncharged or dismissed conduct or relied on that affidavit? Because she goes to great length at the sentencing hearing and during the sentencing hearing transcript to talk about the testimony of the probation officer. They played the recording of your client's contact with the victim. There was underlying detailed affidavits that she referred to, but it was more than that. She cited all of the sentencing factors. She talked about his denial of mental health treatment and services. She was concerned about his manipulative behavior. This is far more. She had evidence and testimony before her. How are we to parse out that she didn't consider everything? You're focusing on just this affidavit and saying the decision was based in whole on that.
Mr. Justice, I would respectfully disagree in the sense that we're not arguing that the court solely considered the child abuse allegations in that affidavit. We're arguing that the court's reliance on that was substantial, not that it's the only thing there. So the court did consider other factors. That being said, if we look at the order the court issued on Pope's written objection and the Rule 35 motion, that's where we can kind of see exactly where the court is drawing a lot of its reasoning from, why the court's doing what it's doing there. But before I get to that, I also want to go to what the court actually had said in the transcript at the revocation hearing. When the video was played, the state's attorney went through and presented different arguments, said, Your Honor, Mr. Pope is threatening the court in this matter. He's threatening attorneys in this matter. He's gaslighting the defendant or the alleged victim here, and things of that nature. Not once did the state's attorney in their argument indicate that in that phone call, Mr. Pope was threatening his wife, or as the court implies, threatening to kill her. And the court later on indicates that, saying, I'm going to paraphrase here, but I don't care about threats to the attorneys. I don't care about threats to the court or anybody else. What I care is we have the defendant in this case violating the terms of probation and by making reference to folks being killed and Charlie Kirk, that the defendant, do that to Ms. Pope in this case. That's the leap the court.
Can't a court infer or go by their prior knowledge that people who violate orders prohibiting contact are more likely to be dangerous? There's a reason for the no contact order in the first place.
Correct.
Violated within 5 days of being put in place. Can't the court take into consideration that there's an increased risk if they disregard the order of the court, that they're not going to care about anything else either?
I would argue that the court can make a reasonable inference from the evidence presented. That being said, that isn't the only thing that the court did. The court also, while it says it took into consideration all of the sentencing factors that are enumerated in our Century Code, one of those factors is whether the conduct was prompted or led on by the victim. In this case, I raised at the revocation hearing that the victim's the one who made the phone call to Mr. Pope. the phone call that is the basis for his revocation. The state didn't argue otherwise, and the court didn't have proof that that wasn't the case. And yet, instead of acknowledging that fact, which would be a mitigating factor for my client, the court instead decided that that's just an excuse and we're going to leave it at that. So if there are no further questions, I would cede the remainder of my time.
Thank you, Mr. Langen. Mr. Peterson, when you're ready.
Chief Justice McEvers and honorable justices, counselor, may it please the court. Given Justice Freese's point about Rule 35B, I'll just give the cliff notes on that. The sentence is within the statutory maximum, and when you look at appellant's objection, the brief and the reply brief, it's all asking for as a matter of leniency. So with that, issue 2 or point 2 of why the district court sentence should be affirmed. A review of the record does not demonstrate appellant's assertion that the district court substantially relied on unproven conduct to sentence the defendant, and that the appellant was sentenced in accordance with North Dakota Century Code and North Dakota case law. This court has held that the sentencing court may make reasonable inferences based upon evidence, and that those inferences may be a factor in considering setting a defendant's sentence. So as stated earlier, appellate review of a criminal sentence is generally limited to whether the district court acted within the statutory limits or substantially relied on an impermissible factor. And that standard of review is the abuse of discretion standard. Again, with my first point of the Rule 35B motion, the appellant was sentenced to 4 C felonies, which, as the legislature has authorized, contains a maximum penalty of up to 5 years. There's no sliding scale for C felonies. It's not C felony X is 4 years, C felony Y is 3 years, so on and so forth. It's a maximum of 5 years imprisonment may be imposed, and that the appellant was made aware of this throughout the district court process. Here, the district court impose those sentences to run concurrently, as they are authorized to do so under North Dakota Century Code. And without a statute to the contrary, it's within the trial court's sound discretion of whether a sentence should run consecutively or concurrently. To my second point, the record does not support appellant's assertion that the district court substantially relied on an impermissible factor. The district court stated in its order on objection that it had considered the 14 factors under Century Code. At the revocation hearing, the district court listened to the exhibits that were played for sentencing, and
Can
also...
the court consider that if that part of the appeal is dismissed?
Apologies, Your Honor, I didn't hear the first part.
The judge's detailed findings in denying the Rule 35 motion, that's not appealable. Can this court consider the judge's rationale in that non-appealable portion of this case?
I don't believe so, Your Honor. In my research, I don't believe so, because he's sentenced within the maximum and he's sentenced as authorized by Century Code.
And Mr. Langang has argued that we should look back at the initial sentencing hearing, and correct me if I'm wrong, but there was no appeal from the original criminal conviction, correct?
Correct, Your Honor.
So the time to make any arguments about that, are they foreclosed? Can he bring up what was discussed at the original sentencing in order to show the court relied on impermissible factors at the original sentence when that wasn't appealed?
Sorry, or just if I can rephrase your question to make sure I understand it, whether or not he can appeal what was said at the change of plea hearing?
Yes.
I don't believe so, Your Honor, and the reason for that is the district court accepted the plea agreement and therefore they were bound by the plea agreement. So while appellant and defendant may disagree with what was said, the district court abided by the plea agreement that it did not like the plea agreement, but it abided by it.
And yet we've said that if the court relied on an impermissible factor, would that be considered an illegal sentence or a sentence entered in an illegal manner? Because an illegal sentence, if it's an illegal sentence, it's always, you can appeal it, right? I mean,
I believe so, Your Honor, yeah.
they could bring a Rule 35 motion under the other section
Yep.
for an illegal sentence and bring that.
So if I may just ask a clarifying question, are you asking if the illegal sentence would be, say, a sentence that goes beyond the statutory maximum, and the appealing a sentence imposed under an impermissible factor, while not an illegal sentence in the sense of within the maximum, that it would still be
Imposed in an illegal manner.
imposed?
Yeah,
Yes,
yeah,
correct.
yeah.
I think if the record actually demonstrated that a district court judge did rely on impermissible factors, then such as, and in my research, I found the four impermissible factors, and appellant brings up the pending criminal charges, but that's not the case here. The defendant pled guilty to the 4C felonies. The B misdemeanor was just adjudicated as guilty in time served. And then the defendant also admitted to the conduct in the revocation, which then the sentencing reverts back to the original 4 charges, which allow for up to 5 years. But in the revocation hearing and in the order, the district court lists its reasons for the sentence that it imposed.
Counsel, if a district court cannot rely on pending charges, does it make sense that you can actually rely on dismissed charges? I mean, pendings could at least still be proved. A dismissed charge, either the state has agreed there's not grounds, or for whatever reason, it has been dismissed. So it seems that's even worse than relying on a pending charge that has not been resolved in the defendant's favor.
The state would agree that there is kind of a correlation there of a pending charge has not been proven, therefore that can't be used as a sentencing factor. A dismissed charge, as Justice Barr, said, has been dismissed, so therefore that should not be used. The state doesn't disagree with that position. However, in this case, he pled guilty to the 4C felonies as well as admitted to the allegations. Therefore, the sentence reverts back to those 4C felonies, and he was sentenced in accordance with Century Code. And the district court laid out its reasons in both the order on objection and during the sentencing hearing, or the revocation hearing.
Well, from what I've heard, understand from your argument thus far, is you're really focused on the third prong of what Mr. Langang, the substantial reliance. Do you agree that to rely on a dismissed charge, if the court substantially relied on that in sentencing, that would be impermissible?
I would agree with that, Your Honor. However,
Go ahead and finish your thought. I want to test that properly.
however, I would just reiterate that the court listed its reasons for why it gave the sentence it did.
So I think that's appellant's argument is to extend Hoverson along the lines of the questions by Justice Barr. In thinking about this, though, my intuition went largely the same way, that clearly if it's pending, if you've been acquitted or the charges were dismissed, that seems like a stronger case for not considering it. And so to answer that question, I found a case that I don't think anybody has cited, State versus Wells, that dates from the same era that these you can't consider pending criminal charges cases. And let me just read a passage and get your reaction on your feet. And I apologize for you haven't probably had a chance to read this, but it says, inadmissible evidence may be considered in sentencing, cites a case. The court may even consider evidence as to crimes of which the defendant was acquitted, citing cases, arrests which did not result in convictions, again citing cases, and criminal conduct as to which no charge has been made. So I don't see a red flag on that in Westlaw. Again, just your reaction off the cuff. It seems like we might have answered the question about whether dismissed, acquitted, no charge at all conduct can be considered.
I think I would just go back that when you look at the sentencing factors that are laid out in statute, I mean, it's one of the factors is the defendant's character. Without being versed in that case, I can't quite make a straight call on that. Does that make sense, Your Honor?
1978, 265 Northwest 2nd, 239. If after the argument you feel like there's something urgent you want to react to, or you think that there's something the court should consider, we have 28K letters that are an opportunity to follow up on, admittedly a no-notice question from the court.
Okay, thank you, Your Honor. Just with some of the, well, one of the things that was brought up with appellant's argument is, well, you can't rely on impermissible factors. A district court judge can make inferences. And with regards to many of the statements that were said about child abuse in the dismissed case, 2 of the C felonies that the defendant pled guilty to were terrorizing and domestic violence. That's to say that the effects on the specific, or for lack of a better term, the targeted victim of the terrorizing, in this case, Mr. Pope's wife, to say that that had an effect on the children as well, which the district court does clarify mental abuse of your wife and children. To say that, to make the inference for a terrorizing domestic violence case against the wife, and that it has an effect on the mother of the kids, on the family unit as a whole, that's a fair inference that the district court can make in such a case in determining a proper sentence. Given which the district court also cites the quickness of the violations, the manner in which the violations took place, continuous abusive and threatening behaviors, victim blaming, and lack of accountability or remorse demonstrated by the defendant. The district court judge is in a position to hear the statements given by the defendant to kind of judge the credibility of those statements and see them firsthand, similar to how a jury can when it comes to giving weight and credibility to statements given in court. So,
Mr. Peterson, while you're collecting your thoughts, what is the state's position on the defense argument that Mr. Pope's due process or confrontation rights may be violated by this process of relying on an affidavit at sentencing?
I think Justice Jensen made a good point of, yeah, a priest can write a letter in favor of a defendant. Victims and victims' family members may write letters to the defendants or to the court arguing for or against a sentence. So, as stated before, the rules of evidence don't apply in the same manner at a sentencing hearing as
Does
they
the
do at trial.
Constitution apply?
Yes, the Constitution would apply in all court proceedings, Your Honor. So,
Would the distinction be the type of statements made in a victim impact statement or a priest letter? For example, if the priest says, this person committed a crime, although never charged 8 years ago, and 6 years ago he committed GSI, but it was never charged or proven, and the court said, I'm relying on those for sentencing. Is that a distinction that this guy gets, he's just not trustworthy?
I think if it was specifically laid out as I am relying on this unproven, unshown, previously unalleged allegation, I think the district court has a discretion to take all statements into account, accord them their proper weight, and make an inference from that.
So would the standard be abuse of discretion in relying on something that should not have been given weight?
I believe so. Yes, Your Honor. Also, just back to some of the things that the district court cited, she was able to hear statements from the probation officer who stated he would not be a good fit for probation given the quickness again, and as well as concern with the level of manipulation that had been demonstrated by Pope.
Were there threats made in the phone call?
Unfortunately, Your Honor, the transcript for the phone call is not in the record. We are able to glean from statements made around the phone call. I believe and I would have to double check real quick if you would like me to.
No, that's all right. I just thought
The
you might
prosecutor
be able
made
to-
some statements regarding what was said or how it was played out. So, and I believe that is record 150.
Thank you.
So, with that, Your Honors, full review of the record would show that the district court did not substantially rely on unproven conduct when he was sentenced to 4C felonies, and at the revocation hearing, with each carrying a maximum of 5 years in prison, to run consecutively as allowed by Century Code and this court's precedent. Appellant had been warned, as this court noted, at the change of plea hearing, and the district court reluctantly accepted but was bound by the plea agreement, and the district court abided by that plea agreement, and appellant's conduct violated the terms of the agreement, which was observed and noted by the district court. If there are no further questions, Your Honors, I'll yield my time.
Thank you, Mr. Peterson.
Thank you.
Mr. Langang, you have 10 minutes in rebuttal.
All right, a few main points I want to make as to the third question I posed at the outset of my argument. I want to present to the court some facts I believe show that the lower court did indeed substantially rely on the allegations contained in the child abuse case affidavit. I don't think we really need to look much further than the sentence that was imposed. The court went from a suspended sentence to 20 years maxed out under the statutory limits for the single violation of having contact with his wife, Heather Pope, from whom he was prohibited from having any contact with. And that's not to discount, a violation of an order prohibiting contact, but that type of offense is an A misdemeanor. 360 days maximum penalty could be imposed for just a misdemeanor violation of an order prohibiting contact. I understand the court, once it finds probation has been violated, or a term of it rather, can revoke and resentence the defendant up to the maximum at that time. That being said, with respect to two of the C felonies he was charged with, those have nothing to do with Ms. Pope. They relate to officers specifically resisting arrest, and the court considered the affidavits repeatedly. If it would have looked at the affidavit in this case, it doesn't describe really the action of Mr. Pope kneeing the officer. It's more so as he, while resisting, turns, his knee makes some inadvertent contact with the officer's groin. That was a distinction that we tried to make in the objection in Rule 35 motion. While yes, there's contact there, he admitted to the offense. It's far less of an offense than if he's just standing there and throws a punch or starts a fight with the officer. There's contact, yes, it caused the officer pain, but if it's during a struggle and not necessarily just strong violence, we argue that's far less than what the court would lead us to believe in its ruling here. So for a single phone call, the court sentenced Pope to 20 years with just credit for time served. Maxed him out, had nothing to say, did not in any way consider that the alleged victim here made the phone call, or that...
Am I recalling correctly, the court even said it would give 85% if it could?
That is correct, Justice Barr. And I believe the remaining part of that quote was the court saying that it thought that this was a violent offense, even though the 85% rule doesn't apply here. Some of the other cases that were referenced, and I apologize, Justice Tufty, I wasn't able to quickly find and read the case you had cited, but the ones that I've cited State v. Smith or State v. Woodman with respect to the pending charge. In those cases, the trial court acknowledged in some sense that there are pending charges, but they also kind of went the extra mile to say this is an impermissible factor, we're not going to consider it, or in addition to that, laying out all of the different factors that it's considering right away at sentencing. Here, that's not what we argue the district court did. The district court here really focused on the child abuse allegations, and I'll concede that's not the only thing they considered. However, we're not required to show that sole reliance of the impermissible factor. We just need to show substantial reliance.
For the cases you just referenced, I'm quickly taking a look at your brief, but you can just answer it. Were they state court cases or were those the federal cases you were citing to?
Those were state cases.
Okay.
And I would also note those were after trial as well, where the judge had the opportunity to hear testimony from the witnesses. Counsel and the defendant had the opportunity to cross-examine those witnesses, present evidence of their own, and the judge really had a full picture. Here, we're basing things off of unadmitted, unadjudicated, and otherwise unproven affidavits. And we would argue that in doing so and sentencing Mr. Pope to the 20 years incarceration, the court did substantially rely on those allegations, and in doing so created an impermissible factor which was considered. And so for those reasons, we would ask that the court vacate the sentence imposed by the district court and remand this case for resentencing. If there are no further questions, I thank everyone for their time.
Thank you, Mr. Langang and Mr. Peterson. This case will be taken under advisement as all cases are, and this court will be adjourned until 10:45.
All rise.